identifying a condition assigned to the development of these properties. The zoning administrator previously had conducted hearings on 3 separate applications in regards to development of this property, had approved those. Those were not appealed, and so that the applicant maintains entitlement to develop the 3 properties as 3 single-family homes. As part of that, each one of those different entitlement grants included condition number 19. That condition specified a corridor, a wildlife corridor or conservation corridor easement to go across the properties and make a connection. Ultimately, that condition also specified that it would be to the satisfaction of the Santa Monica Mountains Conservancy. That is what is in contention. And so at a point in time, back in approximately November of 2010, the applicant had fulfilled and received sign-off from the Department of Planning as well as Building and Safety, and went ahead and pulled building permits and started to do grading on the site. At that point in time, the council district received a number of calls from constituents questioning as to whether or not, one, the applicant could actually grade on the site at that point in time and have the proper permits, and 2, whether or not that wildlife corridor conservation easement had been prescribed on the project plans as required under condition number 19. It was found in both the Los Angeles Department of Building and Safety's review and the Planning Department's review that that had not been accomplished, and that was not shown on the plans. At that point in time, the Office of Zoning Administration, myself as the acting chief at that time, requested that the Department of Building and Safety issue a stop order, which they did. And so all development stopped at that point in time, so that the applicant comes back to the Planning Department, go through the review on the compliance with condition number 19, and that we show specifically on those project plans that alignment had been prescribed on the plans, and also worked with the Santa Monica Mountains Conservancy to get their affirmation that it was in accord with what they wanted. And so we had Mr. Paul Edelman came into my office and spoke with me. I had the council district come in representing the constituents at that time and articulating their concerns, as well as the applicant came in and met with me. All of this was not a revisitation of the entitlements themselves. It was solely to look at clearing that condition number 19. And looking at that condition, the condition prescribed that it's to the satisfaction of the Santa Monica Mountains Conservancy. That is problematic. That is an illegal condition. And in reviewing that condition with the city attorney, it was identified that legally the city cannot concede authority to an agency outside of the city's jurisdiction. Santa Monica Mountains Conservancy is a state agency, not a city agency. And as much as we want to consult with them and work with them, and our intent was fully to have their involvement and participation in this process of reviewing and identifying where that alignment was, ultimately we could not confer that authority to them to make the final decision as to where it was going to be. In the meantime, the applicant came forward. They had suggested at previous points in time when the zoning administrator first looked at the project, certain alignments. Conservancy had also suggested certain proposed alignments, but there was no final decision, to my understanding, that had ultimately had occurred. Applicant came in January, beginning of this year, and brought certain proposals, 5 different alternatives. At the same time, separately, the Conservancy came in with me and spoke with me and provided their different alternatives and what they felt was appropriate. Ultimately, what was started as a 20-foot wide conservation easement was accepted as 18 feet, but the actual location is what was in contention. And so, at the end of all of this analysis and looking at the different locations of the alignment, I'm going to put forward the applicant.
Let's say that.
Stanley Hills Drive is at this part of this, you'll see here, The connection runs along the back of the three properties, comes out at the far end, and comes down and connects at Marywood. What the Conservancy recommended was, this is the applicant's alignment. This is what's shown on proposed plans that ultimately they submitted to me for sign-off. No sign-offs have occurred at this time. There has been no list. There's still the stop order. They are not developing out on the site. If they're doing something, it's within whatever building and safety has allowed them to do at this point in time, just to maintain the integrity. But to my knowledge, there's nothing occurring on the site right now. Everything is in abeyance until they resolve this matter. But the alignment itself runs across, as you can see, and goes out to Marywood. What the Conservancy has proposed is that the alignment runs this direction and then crosses down here through this lower lot. Now, this portion, if you look at the project plan, unfortunately, it's small, but is that is where the driveway would be for that particular parcel number 3. And that creates a problematic issue for the city as far as the potential taking. The applicant has an entitlement to develop that property and to take access to the property. Now, especially when you look at the configuration and what they're trying to accomplish there, is that to minimize the grading and create some retaining walls at the rear portion of the home that would stabilize slopes in the adjoining property, is that was the best proposals they had. And so in order to take access from the upper portion of the site did not make sense. Access to the other homes along this area taken along Stanley Hills, the ones for the other 2 lots would be there, and this would be the next lot down. It makes sense that that would be the continuation for their access. But if there is an alignment there for that wildlife corridor, they would not be able to put the driveway there, and it may preclude ultimately their ability to use that site. That could be a potential taking. And discussions with the city attorney, they also acknowledge that could be problematic. So I'm working with both the Conservancy and looking at their recommendations, as well as what the applicant had given to me, and looking at the legal issues. I ultimately came out with this clarification, which does not modify the condition, does not change the applicant's responsibilities and obligations to provide that corridor. What it did was to identify, 1, the legal issues involved with that, 2, the portions that assigned authority to the Santa Monica Mountain Conservancy were illegal, and we couldn't do that, but that we could continue to work with the Conservancy and ultimately coming to some decision as to where that alignment would be. And so it was my belief at the end of all of this review was that the appropriate alignment would end at Marywood. The applicant has volunteered to seek and request a vacation of Marywood Drive that will continue down to connect with Stanley Hills and ultimately fulfill what the intent with the Conservancy was. Part B of all of this is that the applicant also has a separate agreement, private agreement with the neighborhood constituents. The city is not a party of that agreement. We're not a third party to it. We don't enforce it. It's in some ways sort of similar to what CC&Rs are, in that the enforcement would be through it's a civil matter, and so if there's any contention over that agreement, if the city's not dissolving that agreement, and we don't believe this affects that agreement, I think the neighbors will say otherwise, that's a separate issue. But as far as the applicant's responsibilities to the city and what our authorities are, and what we want to put through as part of that condition number 19, is to prescribe that alignment. This is the alignment that we've identified as being the preferred one. I think you'll hear different alternatives proposed tonight. There may be better ones, and ultimately whether or not the applicant is willing to negotiate and look at other alternatives, I would say that that's probably their decision, not mine at this point in time. I've done the best I can to try and figure out different ways of approaching all of this, and it came through as part of that clarification letter. I think there are contentions as to whether procedurally I have the authority to do so as part of the appeal. I do have the authority. Section 1221A gives me that authority. There's been emphasis placed on certain elements of that when you read the appeal. I think what you have to look at is the full context of 1221A, which gives me the authority, and I will read the language itself. That the zoning administrator shall have the authority to determine other uses in addition to those specifically listed in this article, which may be permitted in each of the various zones, when in his or her judgment, the other uses are similar to and more objectionable to public welfare than those listed. The zoning, any agree by the zoning administrator's determination, may file an appeal within 15 days from the issuance of the written decision. When you look at the context of all of that, I have the authority to do so, both under that section of the code as well as the charter. And I use that authority to make this interpretation. And in clarifying what that condition did, it didn't take away from that condition. It didn't nullify that condition. It didn't disqualify that, nor change that requirement. All it did was clarify that legally it couldn't do it to the satisfaction of the Santa Monica Mountain Conservancy. We could only